Thank you again for your attention. I am happy to welcome our speakers for the first panel, which is with the topic of the class action for today. So I would like to invite Mark, Kristin, Ozan Ayurek, and Ignacio Diogado to the stage. Thank you so much. Maybe give them a round of applause. Welcome, and thank you for being the first to open up the World Litigation Forum for today. We're looking forward to an awesome presentation. You have the mics right here. You just turn them on, and the stage is yours.
I'll make a quick introduction about the topic that we will hear about this morning about class action, as you know. So as business and litigation have become more international, so have litigation proceedings. As you probably all know, a class action is a procedural tool that allows one or more plaintiffs to file and prosecute a lawsuit on behalf of a larger group called a class. While class actions have been common in the US for decades, they historically have not been as widely used in the rest of the world. Class actions vary greatly among jurisdictions. These differences show how developed the procedures are, the type of claims the parties can bring, the parties who can represent classes, whether classes are structured as opt-in or opt-out. We'll talk about that later. And the rules governing settlement, remedies, and financing. Typically, European countries have enacted more restrictive class procedures than the US. At the EU level, the European Commission has long been considering whether to legislate a coherent pan-European approach to class actions. In 2020, a new European directive was published and will require all member states to implement class action mechanism at both the national and the EU levels. Countries are once again beginning to reform their class action policies in the hopes of making class actions more popular and accessible. To discuss all of that, I have the pleasure to be here with two of my colleagues. The first one is Mark Kristin, from August Goodhead, Amsterdam. Mark graduated from the Erasmus University of Rotterdam with master's degrees in both international law and economics. He also holds an LLM in comparative and international dispute resolution from the Queen Mary University of London. Admitted to the Dutch bar in January 2008, Mark spent the first 6 years of his career at Loyens & Loeff, one of the leading law firms in the Netherlands, in both its Rotterdam and Paris offices. He continued his career in international dispute resolution at Linklaters in Amsterdam. From 2019, Mark worked as a senior associate in the International Arbitration Group of Allen & Overy in Paris, and is admitted to the Paris bar as an EU lawyer. His experience includes acting as counsel in corporate and commercial litigation before Dutch court, as well as international, commercial, and investment arbitrations under various institutional rules and in ad hoc proceedings with a focus on energy, infrastructure, financial services, and corporate disputes. Mark joined his current law firm, August Goodhead, in January 2022 to head up its new Amsterdam office and help expand the firm's Dutch group litigation and international arbitration practices. Next to Mark, we have Ignacio Delgado Larena Avellaneda. Ignacio has more than 15 years of professional practice in civil litigation in several Spanish and international law firms, and also as a sole practitioner, mainly in commercial litigation. Ignacio has acted as a lawyer in a number of cases in engineering and construction and banking products overall. Ignacio has worked as well as an investment officer for Therion Capital for more than 4 years and as an external consultant for several hedge funds, advising in the acquisition of rights in portfolio of claims and in third-party funding. As to myself, my name is Ozan Akurek. I am a partner at Jones Day within the Global Disputes Department, which includes both commercial litigation and arbitration. I joined Jones Day back in 2004 from a UK law firm called Herbert Smith. I'm very active in diverse industries, sectors, including, of course, energy, aviation, automotive, IT, transportation, and logistics. I'm particularly involved in the aviation and airline industries, and have represented major manufacturers and airline companies in aviation litigation. I'm also a lecturer in international business law at the University of Paris-West Nanterre La Défense in France. With all of that, I'll leave the floor to Marc Crestin, who will tell you more about the agenda of this first session dedicated on class actions.
Thank you. Thanks very much, Ozan, for this.
Morning session. It's the worst session actually, so
Well, kudos to you guys for coming out this early. Thank you very much. It's a real pleasure to be here at this 2022 World Litigation Forum Europe in Amsterdam, and to be able to speak in front of such a distinguished audience of fellow litigation practitioners. So thanks for being here. We will try to make this session as insightful but also as interactive as possible for a first panel in the morning like this. So we encourage your active participation. Please, we'll have a little bit of time at the end, hopefully, for some open discussion and Q&A. But also during the presentation, we'll try to make it as interactive as possible. So we've divided our session today in. Is this working? Switching it on. Here we go. So we've divided the session into 4 parts. First, each of us will tell you something about the class action regimes in our respective countries. We will then address the pros and cons of our respective class action regimes and litigation in our countries more generally. We will also briefly discuss the phenomenon of third-party funding and how it is used in class actions around the world. And finally, we will look at the future of class actions in Europe in the context of the recently adopted EU directive on representative actions. So I'll speak a little bit about class actions in the Netherlands, which is the jurisdiction that I'm based in. So collective actions in the Netherlands go back many decades. Their origin lies in case law rather than in legislation. And in an environmental case, already in 1986, the Dutch Supreme Court found, in line with earlier lower court decisions, that claim organizations can bring a claim on behalf of other persons. And although at the time there wasn't really any legislation in place that was designated specifically to class actions, other avenues were used to bring a class action, for example, on the basis of assigning claims to a claim vehicle or giving a mandate or power of attorney. And in most instances, as is still the case today, it's a foundation or association that was used to initiate proceedings and to bundle claims of individuals. And those can be pre-existing foundations or ones that are incorporated specifically ad hoc to bring a particular claim. There is no restriction on the type of claims that can be brought in Dutch class actions. It's available to all causes of action and all persons harmed that are part of a particular class with similar harm. Even corporates can join a representative action, which is different from, for example, the English CPOs. And looking a little bit at the current legislation in place, you will see there are three laws, effectively, three acts. So the first one came into force in 1994, which is the Class Action Act, the WCA. That's legislation that was enacted allowing non-profit organizations to bring collective actions for injunctive or declaratory relief. The legislator at the time was contemplating whether allowing collective actions could bear a risk for society becoming more polarized and litigious. But the legislator ultimately decided that it could actually be better to litigate sensitive matters on behalf of a large group in court, and that would rather depolarize issues because it would allow for a proper way of expressing discontent of a group of people. However, at the time, collective claims for monetary damages were not yet allowed because the legislator found that it could or would inherently require individual determination of losses. Then, a little over a decade later, in 2005, the Act on the Collective Settlements of Mass Damages, the WCAM, was enacted to facilitate collective settlements. And under that mechanism, a paying party and the claim organization could jointly petition the Amsterdam Court of Appeal to declare a settlement binding on a group of persons, subject to an opt-out mechanism. And that settlement mechanism is still in force today, and it's been used on 9 occasions so far. So not a whole lot, but these were very large group settlements, oftentimes with a cross-border element. You may be familiar with the Converium case or the Shell case. Those were huge international settlements that were concluded under this regime. And then finally, in 2020, so very recently, the new Act on the Settlement of Mass Damages in Collective Action, the WAMCA, as we call it, WAMCA, was enacted. And this essentially amended the pre-existing collective action mechanism. And under the new WAMCA regime, class actions can be brought also for monetary damages, and I will talk a little bit about that. It's maybe good to know that there is a cutoff date from when the old law applies and when the new law applies, which is the 15th of November 2016. So for any harmful event that occurred before that date, the old WCA Act will apply, and any event that occurred after that, on or after that date, it's the new WAMCA regime that applies. So let's zoom in a little bit on this new regime. What's the difference actually with the old one? So one point I've already highlighted is that claims for damages are now possible. So before, the WCA could only be used as a stepping stone to then initiate separate proceedings in which monetary damages could be sought. Now, under the new WAMCA, much like a US class action, it is possible for representative organizations to seek monetary damages in one and the same proceeding. I also mentioned, and that's different to many European jurisdictions, it's an opt-out system. So again, resembling somewhat the US system. Which means that it will affect all persons represented that are part of a particular class. There is a distinction that's being made between Dutch nationals or Dutch residents and non-Dutch residents. So the system is opt-out for Dutch residents, but it is opt-in for foreign residents. So anyone that's not residing in the Netherlands can join the class, but has to actively opt in, whereas for Dutch plaintiffs, it is an opt-out mechanism, so they will automatically be part of the class without them needing to sign on to the claim. And there are a couple of opt-out opportunities, which I will address in a second. Another important feature is that there are relatively strict requirements for the claim organizations or foundations that bring the claims compared to the old law. In particular, claim organizations have to be sufficiently representative, so there are a number of conditions that they have to meet to be able to bring a claim. There must also be certain governance in place, meaning that a claim organization needs to have a management and a supervisory board. And they must show that they have sufficient resources and control over the action that they bring. And finally, another feature is the appointment of an exclusive representative, as it's called under the Dutch law. Once a claim has been filed through a writ of summons, and that writ of summons has been published in a central registry, which is now required for all new VAMCA claims, there is a 3-month period that is triggered within which additional claim organizations may file collective actions on behalf of injured parties and which relate to the same events with similar facts and similar causes of action. And that period can be extended by another 6 months. So you can have competing claim organizations filing the same type of claim on behalf of largely the same class, in which case the court will then appoint one of the claim organizations as exclusive representative, and there are several conditions that the court will take into account, or several factors that it will take into account to make that decision. Unfortunately, the law is so young still that we don't really have any live example of that. There may be a first one that we will see now with the, as you will all probably be familiar with, the Dieselgate scandal with the defeat devices that were placed in diesel cars all around Europe. That's one of the class actions that is ongoing in several jurisdictions across Europe, including the UK. A large settlement was recently concluded. That claim is also pending in the Dutch courts against Volkswagen, against Renault, Nissan, against a number of car manufacturers. And there have been 3 competing claim foundations that have brought the same claim. So we will see how this pans out and which claim organization will ultimately be appointed as the exclusive representative. It's somewhat like a lead plaintiff, if you will. The other organizations will still be part of the claim, but only the exclusive representative can make procedural actions in the proceedings. Just to show you a small graph on the recent act. Again, as I said, it was only introduced in 2020, so there is still relatively little statistics available. But you can see that in 2021, the number of cases that was filed under the new regime already doubled as compared to the first year in which it was enacted. Now in 2022, we have around 11 cases that have been filed so far. Obviously, the year is not yet over, so there are still more likely to come. I doubt that we'll reach the number of 2022, but still, you can see a growing trend of class actions being filed in the Netherlands, not only under this regime, but obviously also still for some under the old regime, depending on the cutoff date. And with that, I will hand over to Ignacio to tell you something about the Spanish regime.
Thank you very much. Also, first of all, thank you very much to the organization, to the World Litigation Forum for the invitation to be part of this honor panel. I really would like to speak this morning about the development of class actions in Spain. The first thing that I have to say that is, unfortunately, in Spain, the class actions are not so well developed as in other countries, such in the UK or even here in the Netherlands, as Mark has explained to us. Unfortunately, there are in Spain the class actions, the only entities that are entitled to use these kind of actions are just the consumer and user associations. And I'm afraid that they have not been so successful as in other countries, such as in Netherlands or in the UK, USA or Australia even. There is only one paragraph in the Spanish procedural law. I will just quickly go through it, which states basically that when those damage by a harmful event are a plurality of undetermined or difficult to determine consumer or users, the legal standing to sue in court to defend these diffuse interests will correspond exclusively to the consumer and user associations that are in accordance with law, the only representative and the only people, as I said before, entitled to pursue these class actions. Under this procedural law, the class actions in Spain bring a number of consumers and users into the class action, but they don't have the right to opt out. They don't have the opt-out option to leave the class actions. So there is just an opt-in option. Sorry, which is basically based or with the purpose of having a res judicata, which is, as you said before, Mark, and with your former regime, they are not able to ask for the damages at the end of the day with these class actions. So this leads to the following question, which is, are we familiar in Spain with consumer and user associations bringing this type of class actions? The short answer is no. There's a number of difficulties. We have a lack of culture in class actions. We have a lack of counsels and lawyers specialized in class actions, and you can deduct from what I said before that if you cannot ask or pursue the damages you have suffered, if you're a consumer or a user, you will prefer to go on an individual basis instead of user or being part of a class action that even may take longer, and there will be just a declaration judgment at the end of the day. Because, as said, the consumer and user associations in Spain can just ask for the cease of an abusive clause and similar things, but what they cannot do in Spain is to claim for the damages of the individual members of the class action. However, I am not going to be so pessimistic because in Spain, I think we have been, during the last couple of decades, quite creative to overcome the lack of an effective type of class action. So how we have done ourselves capable to claim for the damages suffered by the individual when you have not access to a proper class action? Well, there are different manners. As Mark mentioned before, we have the assignment of rights to the SPVs. Of course, we don't have so much experience as they have in the Netherlands or in other countries, like in Germany, as I heard, the very well-known case of the SPV and the assignment of rights in the drug cartel case. If I remember correctly, they had some problems as well there. And I have to recognize that the assignment of rights to SPVs is not, there is not so much experience in this field, and I think that the judge and courts are a little bit reluctant of this way of course, we have we can try to accumulate or bundle cases of individual in a single claim, but there are many judges that tend to reject this sort of mechanism, even if it is agreed between the parties and the lawyers of the counterparties, which doesn't make any sense, also because it goes against the economics of the courts. But I think that the more and more we have more experience, we tend to see how we can engineer our claims not to be rejected at the end of the day, this bundling of cases. Also, we have more and more judges open to this kind of mechanism because they admit that it is the best option for the economic for the economics of the judicial system as well. Of course, as I said, well, we thanks to the fact that in Spain the legal expenses are much lower than in other jurisdictions, obviously much lower than in the UK or in the USA. There have been a number of law firms very brave, able to bring thousands even of individual cases just by their own self and working on success-free basis, because I have to highlight that in Spain, for the last 15 years, we have been allowed to work the lawyers on success-free basis purely, even 100%, which is a main difference with a number of European countries. This, together with the fact that the rest of the legal expenses are quite cheap in Spain, has led to a number of law firms, as I said before, which have been able to bring thousands of cases on individual cases. And of course, the third-party funding. The third-party funding has become fundamental in the last years in Spain. It has come gradually to our country, but certainly to stay and to remain. Third-party funding is helping out these platforms of massive litigation or these law firms that I have already mentioned, not to strangle themselves financially. And of course, we have to be very careful of the transposition of the new directive of third-party funding, where we have a number of recommendations from the European Union Commission to protect the individuals and their rights with the potential abusive tendencies or acts from third-party funders. But I should say that we have to be very careful with the restrictions that this European Union directive may have, because it may have a lot of impact also in this industry of the class action development. And with that, I will let my colleague from France. Thank you very much.
Thank you, Ignacio. Right. Regarding the French class action, our regime has been enacted on March 17, 2014, almost 10 years ago. It's called Loi Hamon, because of the name of the minister at that time. And we had like several years of debate as to whether we should implement class actions. And at the end of the day, we decided to have one called class action à la française, probably because we wanted to make it very different from what they have in the US, and maybe this is the reason why it doesn't work. We'll talk about that in a minute. It really started with the EC recommendation back in 2013, in June 2013, which urged member states to have a redress mechanism in their own system, just to make sure that they have effective access to justice. And then the scope of the class action procedure has been gradually broadened If you look at my next slide, you'll see that we started with the consumer and competition law violations, and now with the healthcare modernization law, we can bring class action for personal injuries suffered by users of the health system. And today we can even bring class actions for discrimination, environment, and personal data protection. So the scope, as I said, has been broadened. Unfortunately, it still doesn't work in France. We have less than 30 class actions that have been filed in France. We'll see in a minute whether the EU directive will have an impact on the number of class actions filed. The way it works in France is that you need to have a public accredited consumer association who will file the class action on behalf of the consumers. So this means that lawyers are not entitled to file class actions on behalf of the consumers. So lawyers cannot go and knock the door of the consumer to say, hey, I have a case for you. I know that you've been using this product, and as you know, this product is defective, and you can bring class action. Don't worry about the fees. I'll file the class action, and we can talk about the fees at a later stage once we have the judgment. So this is not allowed in France. Lawyers are not, entitled to file class actions. So you need to go through one of the 15 consumers association who can, bring that class actions on behalf of the consumers. We used to have, just to let you know, we used to have something similar to the current class action called the action for the joint representation of consumers, where we could bring an action against a company. A consumer association was allowed to bring an action against a company only if it has been retained by only two consumers. But again, this was very rarely used. It was unknown by the litigants, and we had also an action called brought in the collective interest of consumers in case of a criminal offense committed by a professional towards the consumers. Again, that action was unknown, so this is also one of the reasons why we decided to have a proper regime on class action. In terms of proceedings, we have a 4-stage procedure. Once you file your class action, the first phase is the assessment by the court of whether the requirements to bring a class action are met or not, and the liability of the professional. So basically you will have a judgment engaging the liability of the professional, of course, if it has committed a breach. And then, contrary to the Dutch system, we have the opt-in phase. So depending on the requirements set by the court, the consumers can join the group. This can be done through the judgment being published in national newspapers, where the consumers can be informed of the judgment and then can decide to join the class so they can get compensated for the loss they have suffered. The third phase is the liquidation of the assessed loss. Basically, the consumer association will handle the transfer of the amount that has been awarded by the court. And then, if there is any difficulty related to the liquidation of losses, the court can handle those difficulties and issue another judgment. Please also keep in mind that consumers who have not decided to opt in can also file separate action against the professional. So, as I said, unlike US class actions, consumers must explicitly consent to their inclusion in the group. And the court will determine how to inform potential consumers. As I said, the judgment can be published. And there will be, of course, a deadline to join the court. And again, non-parties are entitled to file separate actions. In terms of remedies, and that's also something important to keep in mind, we don't have punitive damages in most civil countries, so we don't have punitive damages in France, which means that consumers have less incentive to start class action in France, to be honest. Initially, class actions were aimed at compensating material loss suffered by consumers. Moral prejudice was excluded, but it's now applicable in discrimination cases or in cases where you have a breach of personal data. The main principle in France is that you are only entitled to get the full reparation of the loss, no more. So basically you have a fault, a damage, and then a causal link between the two of them, and full stop. You can't get any punitive damages. They don't exist under French law. So we've had a couple of cases in the consumer area, in the health sector, in the personal data area, but nothing really substantial so far. So let's now discuss the pros and cons of our respective system with the Dutch class action first.
Thank you, Ozan. Yeah, so moving on to the second part, as announced in the beginning. So we'll talk a little bit about the pros and cons of our respective class action regimes, starting with the Netherlands. So the pros, I touched upon this before. Obviously, the first point is that you can now bring a claim for aggregated damages for the entire class. So this is unlike the old system, but also unlike, for example, the UK representative action mechanism, which requires class members and the representative to have what they call the same interest. This has been nuanced slightly with a recent judgment between Lloyd and Google, but still there are some restrictions there, and in the Netherlands you can bring a claim for aggregated damages. Now, the second point is the opt-out regime. As I touched upon before, class members have two opportunities under the new regime to opt out of the class if they want, if they don't want to be part of the collective claim. The first opportunity is once the exclusive representative has been appointed by the court. And a second opportunity may exist if and when a settlement is reached between the claim organization and the defendant. So the court will usually has to try and get the parties to settle. Sometimes it works, sometimes it doesn't, but if and when there is a settlement, there is a second opportunity for class members to opt out. Now, as I said, there is a distinction between Dutch and non-Dutch residents. So for the non-Dutch residents, obviously the action is opt-in. Unless the court decides otherwise, there may be cases in which the court decides, even for international claimants, that the opt-out mechanism shall apply. Again, you can contrast this, for example, with the English GLO, which is an opt-in device, as well as with the German class action regime, which also has an opt-in mechanism. And then maybe one of the main disadvantages, or why the new law has been criticized, is because of the more stringent requirements for the claim organizations bringing the claim, one of which is the so-called scope rule, which provides that the collective action must have a sufficiently close connection with the Dutch legal system. And that connection can exist under three circumstances. The first is when the majority of the represented class members are resident in the Netherlands. The second option is if the defendant has its seat in the Netherlands, but that then requires additional circumstances that indicate a sufficiently close connection with the Netherlands, or if the unlawful act occurred in the Netherlands. And obviously this is somewhat restrictive in the sense that if you bring an international case where the harm occurred abroad, or where the majority of your claimants are domiciled abroad, it is more difficult to qualify under this new regime. Now, looking at litigation in the Netherlands, zooming out a little bit and looking at litigation in the Netherlands more in general, what are the pros and cons of this jurisdiction? Obviously, one of the big advantages is that there are, like Ignacio said, for Spain, relatively low court fees and litigation costs. Generally, court fees in the Netherlands are relatively low, and also in the Netherlands there is a default position that the losing party pays the winning party's costs. However, these costs are limited to court fees and fees for lawyers that are capped, in a sense, at a preset amount, which depends on the number of actions taken in the proceedings, so the number of submissions, the number of hearings, multiplied by an applicable rate, which currently is around 4,000 euros per legal action. So you can imagine that even in large cases with several submissions and maybe a couple of hearings, there is only a very small percentage of the costs that will ultimately need to be paid in case the case is lost. Another big advantage is that the Netherlands is regarded as an efficient and unbiased court system with competent judges. In the World's Justice Project's Rule of Law Index of 2021, the Netherlands ranks 6th across 139 countries worldwide. Only the Scandinavian countries rank higher. Dutch litigations are known to progress relatively quickly, with an average of 130 days from the notice to appear until the final judgment. I must nuance that slightly because in practice that's not often achieved, especially in these big class action cases. It will usually take longer, but still, compared to some other jurisdictions, the Netherlands is relatively efficient. I will go through the other points a little more quickly. Obviously, levying prejudgment attachments is something that's frequently used in Dutch proceedings, which is quite easy on an ex parte basis. There is no forum non-convenience rule applied by the Dutch courts, as you have, for example, in the UK. So there are only limited grounds pursuant to the Brussels I recast regulation on the basis of which Dutch courts can actually declare themselves incompetent to hear the proceedings or stay the proceedings in favor of an action being brought abroad. And there is a possibility now at the Netherlands Commercial Court to litigate cases in English, but that's only if parties agree. There are also, not many, but a couple of disadvantages. Obviously, the flip side of a low adverse costs being applied is also that if you win a case, the amount of costs that you can recover at the end of the case from your counterparty are relatively limited, so you will never be able to recover your full litigation costs. And maybe another slight con is the fact that there is no discovery or disclosure in Dutch litigation. As you may know from US or UK litigations, there are very limited possibilities for requesting documents in proceedings from the other side. And I will hand back to Ozan.
Thank you. So I think I have already answered this question as to whether class actions are successful in France. Unfortunately, they are not, or fortunately, depending on where we sit, they are. As I said, we have less than 30 class actions that have been filed so far It's very difficult to track the number of class actions because we don't have, at least in France, I don't know about the other countries, but we don't have a database where you would, see all the class actions that have been filed. So the only way to know is, if the class action goes till the end, i.e. that you end up with a judgment, then you can track, the number of class actions because you have a judgment. So that's one way of doing it. If the class actions gets settled, for instance, you don't have any possibility to know that it has been settled unless, it's in the press. If it's in the press, on the web, then you have the information. If not, very difficult to track it. So there is an absence of records here. So this is also the reason why we haven't seen any class action or any French courts awarding damages to consumers. One of the reasons why it has failed is, first of all, the length of the proceedings. It takes ages to get a judgment, unfortunately. And I'm not, referring to class action. Generally speaking, our judicial system, tends to be a bit slow. And in particular, in class actions where you have a couple of stages of procedure, it's even longer. So that's one reason why it has failed. The other reason, and I touched that before, is the lack of financial incentives. As I said, we don't have any punitive damages, and I think that's probably the reason why consumers, are not willing to start class actions. Just to give you an example, 10 years ago, I was involved in an aviation, in an aircraft accident litigation, and it wasn't a class action at that time because we did not have that regime in place, but we had like 600 members of the victims bringing a massive action against US manufacturers, and the case was clearly connected to France. All the victims were French. The flight was was from Egypt to Paris, so the case was connected to France. And this is, the typical product liability case. And what they did was to go to the US and start an action in the US rather than go to France where the case was connected. And I talked to the adverse lawyers a couple of times and I said, why did you go to the US? And the answer was very clear. It's because of the damages, because the amount of damages you can get in the US has nothing to do with the amount of damages that you can get in civil law countries. So lack of financial incentive is another reason for that failure. The fact also that you have to go through a certified consumer association is also another reason, because it makes the whole system complex. As I said, lawyers are not entitled to bring damages. We don't have discovery, and Mark mentioned that before. We don't have discovery in France either, which means that you, as a claimant, you have to build up your case. And it's not an easy thing to do that when you have a big corporation in front of you, in particular when the case is very technical. So you have to come up with your own evidence. If you need some evidence, you can still ask the judge to force the adverse party to submit that specific evidence, but you have to identify that evidence. So if it's a contract, you need to tell the judge, well, it's a contract that has been entered into by this party and this party, that it is dated, I don't know, June 2014. So you have to be very specific in your request in order to avoid what we call, phishing discovery. And, it's also difficult to assess the damages suffered by the consumers. Very often we work with financial experts to do that work. Consumers association, they are not used to do that work. We have large international law firms based in Paris who do that all day long, and I think in some cases consumers associations are not well equipped to do that. Now, let's say a few words about third-party funding, and we are. You want to say something, Mark?
Maybe we do the poll first. So, before I'll pass on to Ignacio to tell you a little bit more about third-party funding, we've mentioned that term a few times now already in our presentation. It's obviously an important feature of class action litigation in particular. This is where we get to the more interactive part, and we really hope that this works here. If you could all get out your mobile phones, please, and I hope you have wireless or 5G connection. If you could go to this website called www.pigeonhole.at. You can also scan the barcode, if that works, or you go to the website on your browser. And then you enter the passcode, which is the date of today, 03/10/22. And if all goes well, you should get a question. You should get 4 questions, but I only ask you to answer the first 2 questions, please, which deal with third-party funding. The first question is, who is familiar? First of all, can you all access the website? Can you all see? All right. So the first question that you will see pop up is, who is familiar with third-party funding and who has already used it in practice? There are 4 possible multiple-choice answers here. And the second question is, do you think third-party funding is necessary to have a successful class action system? And I will try now on the screen to project the results. Just bear with me 1 second. The address just. Apologies for that. Slight hiccup here. Well, I'm not sure if I'll be able to project the answers on screen, which is a shame. But let me tell you what the outcome is. I can see through my device. So who is familiar with third-party funding and who has already used it in practice? So the first option was, yes, I have used it in more than 5 cases. That's only 3.5% of you. Then yes, I have used it in at least 1 case. That's 10% of you. I know what it is, but I have never used it in practice, is 65%. And I have never heard of it until today, 20%. So most of you know what it is, but I've not yet used it in practice, but some of you have. So that's encouraging. And then the second question, do you think third-party funding is necessary to have a successful class action system? 13% of you have said yes, and it should be unregulated. 27% of you have said yes, but it needs to be regulated. And 59% of you said it depends on the jurisdiction and or the type of case. But no one has said no, there are better ways to finance these cases. So again, apparently you're all in agreement that third-party funding is
The
something.
results have been really interesting. I really invite all of you to look at the European Union Commission recommendations for the regulation of the third-party funding, because if you have a sense of, or at least as the majority of you have said that you know what third-party funding is, it is at least quite interesting to see what are the limits that the European Union is willing to put on this figure. Okay, I will try to speed up my presentation, because otherwise we are running out of time and somebody is going to cut our balls. Yeah. Just to make a quick introduction, third-party funding, generally speaking, is when there is a third party who generally speaking bear or pays for the legal expenses associated with a litigation, just in exchange of a part of the damages or the proceeds at the end of the litigation, and only if this litigation is successful. So this means that this is a non-recourse finance, which means that if there is no win, there is no gain for there is no money for the third-party funder, and this is something really interesting and to be understood by the associations and of course for the consumers and the companies who are willing to use this figure. I think you may think that what's the reason these guys have brought this thing of the third-party funder in a presentation which was used to be only about the development of class actions. It's mainly because the three of us thought that class actions are entirely tied to third-party funding in Europe. And probably the development of the class actions in each of our countries have been together and evolved in a correlated manner with the evolution of the third-party funding in all of our countries. And as you will see in a minute, this is mainly the reason why in the UK there is a huge explosion in class actions. And also in the Netherlands, in comparison with the rest of the countries of the European Union. I have rescued from Google this CMS survey. I hope that there is no lawyers from CMS to sue me about the copyrights, but I will do it anyway. Okay. This is about litigation funding explosion driving class actions across Europe. This is from August this year. And it says that it showed that the number of people involved in the UK competition class actions as June 2020 almost tripled to 171 million, and in 2021 there were 7 new competition class actions filed on behalf of 100 million people in aggregate. I think these figures speaks in their own self. It is a massive use of the class actions in the UK, and it is just because all of them were third-party funded. This press release continues saying, however, the number of class actions filed in Europe in 2021 was virtually unchanged at 110, up just one from the year before, but a huge jump from 2019 when the figure was 68. So the number of class actions and growing, and as I told you before, I have been working in the third-party industry during a number of years, and I used to work for a UK third-party funder trying to develop the Spanish market, and when they used to have this sort of class actions, my only role was not pursue these claims and fund these claims in Spain, was only try to bring Spanish claimants to the Netherlands or to the UK class actions, where they have even mechanisms to allow people from the rest of Europe to join their own class actions, which is very good for them, but it's a little bit poor from our domestic point of view or domestic jurisdiction to say our clients that they have to go to some other countries to pursue the rights. Yeah, but this is what it is. In the other side, there is a brief summary in this press release which says that the costs of class actions are often met by third-party litigation funder, but equally, introduction of new class action mechanisms increases the number of potential class actions, which attracts funding capital. There is a two-way supply-demand relationship. I think this last sentence summarizes what we, the three of us, wanted to say when we introduced or we added the third-party funding industry to this presentation, which is mainly that we all the three of us think that if there is no third-party funding well regulated or there's a total freedom for it to work properly in our countries, there will be no class actions, and I will come when we conclude. I will say what I think about mainly what will be the potential effects of the European Union directive in the class actions. Just to say one word about the development of the third-party funding in Spain, must say that that third-party funding in Spain is wonderful, just to be honest, and it is evolving in a very positive manner, and even we are looking more and more monetization of claims, which is a step forward in the world of the litigation funding. So I will let my colleagues to continue because we have only 5 minutes more.
I think in the interest of time, although we did start a little bit late, but
Let's do maybe 10 or so.
yeah, no, we will move a little bit more quickly. So maybe we jump straight to the EU directive, or sorry? Yeah, sure. This does not seem to work anymore. Maybe someone can help us here. I cannot. Oh, there we go. Does it work? It does work now. Okay. So we'll skip this. Yes, thank you. So let's talk a little bit about the new EU directive. Just wanted to show you, before doing so, to look a little bit about the to the different jurisdictions in Europe and where we currently stand with class actions. As you can see, the UK leads the way by quite a mile in terms of the most active jurisdictions in Europe for class actions, followed by the Netherlands as the first EU country with the number of claims filed in the past 5 years, and then you see some of the other countries coming behind with, for example, Portugal having a lot of new cases in recent years. So what is the new EU directive on representative actions about? Ignacio already touched upon it. It's been many years that the European Commission has been considering to introduce a collective redress mechanism for the entire European Union. It was only on 25 November 2020 that the European Parliament finally adopted this new directive on representative actions for the protection of the collective interests of consumers. That's the full name. This directive introduces a harmonized model for representative action in all EU member states that guarantees consumers are well protected against mass harm while ensuring appropriate safeguards to avoid abusive lawsuits. And under this new directive, all member states must put in place at least one effective procedural mechanism that allows qualified entities, so consumer organizations or public bodies, to bring court actions to seek an injunction or redress in a collective proceeding. And member states of the EU will have until the 25th of December of this year to implement the EU directive into national law, and then the new procedural rules must be applied to new collective claims as from 25 June 2023. The Netherlands was the first country actually to vote to amend its current class action regime, the WAMCA, to comply with the directive, and a lot of countries are expected to enact legislation in the coming months. It is hoped that the new directive will become, or will bring in a new era of consumer protection across the EU and ensure a collaboration between member states in collective actions. And it is possible also that new European hotspots for collective actions will emerge after June 2023 as the new regimes are unveiled in full. So what are the main elements of this new EU directive? The first is that its scope is relatively limited because it only applies to consumer law, and there are 66 loosely termed consumer protection EU laws in the member states applicable, which they range from data protection and financial services to health and energy. So in terms of sectors, it's quite broad, but in terms of claimants that may be represented, it's relatively limited because it's only applicable to consumers. Then the second feature is that there must be a qualified entity bringing the claim, so member states must set up systems for establishing and registering qualified entities who will be entitled to bring those claims under the directive. Those qualified entities can bring both domestic and cross-border collective actions. So for cross-border collective actions in particular, there are certain requirements on top of the domestic requirements that must be fulfilled. For example, qualified entities must have existed for at least 12 months to be able to bring a claim. So only established qualified entities will be able to bring cross-border claims. In terms of redress and remedies, the directive provides that countries must put in place either a possibility for injunctive relief and or redress. Punitive damages, like it was already touched upon by my fellow speakers, are excluded also from the EU directive. In terms of the mechanism, it is quite liberal in the sense that countries can opt for an opt-in or an opt-out mechanism, so that's free to the country to decide. The loser pays principle applies under the EU directive, and there are provisions for third-party funding in the sense that this is permitted under the directive, but it must be, there must be certain safeguards in place. So it must be clear that the third-party funders do not influence the decisions, the procedural decisions and strategic decisions of the qualified entity bringing the claim, and that they do not deflect away from the collective interests of the consumers. And very, very briefly on the implementation of the new directive in Dutch legislation, the new regime, the WAMCA regime that was enacted 2 years ago, is already more or less EU directive proof in the sense that it already has most or almost all of the features that the directive requires. There are only a few very small amendments that were necessary to be made. One, to the definition of qualified entities, or at least adding the possibility of qualified entities bringing cross-border actions and then having to comply with different requirements than under the domestic regime. And there was an amendment with regards to dual representation. So if consumers bring a collective claim in one country, they must declare before the courts in the Netherlands that they have already done so, so they cannot bring the same claim also before the Dutch courts.
Well, I guess the main question here is what will be the impact of that EU directive on our respective legislation. And I went through the characteristics of that EU directive, and I can say that the changes do not appear to be fundamental here. I haven't seen anything that will be a game changer for the French system. The only thing which might be interesting is to, introduce a bit of, opt-out regime in our own system, in particular for claims that are not for, the small claims. If we could have that in our own system, that would be a game changer, because that would ease the class actions. The other thing I wanted to say is also about the fact that the directive recognizes third-party financing, but only to the extent that it is allowed by national laws. So I have this impression that this directive is all about, recommendations, but there is no obligations on member states. So I think the aim is here to have a harmonized system in all member states, but that's it. So the short answer to the question as to whether this directive will have a big impact and whether this directive will increase the number of class actions, at least as far as France is concerned, I would say no, it's not going to have an impact. As I said earlier, there are two things that could, according to me, that could increase the number of class actions in France. The first one is to allow lawyers to bring class actions on behalf of consumers. Of course, I mean, we need to have some safeguards in order to avoid abusive actions, but that's probably one thing. The second thing is to introduce a bit of punitive damages in our own system, again, with some safeguards in order to avoid abusive class actions. I think those 2 points could be the game changer in this class action industry.
Thank you very much. I will be very short because I completely agree with what my fellows already said, and my conclusions are pretty similar. First of all, as Austin has already said, but I want to highlight this point, the European Union directive is full of recommendations. There are no obligations for the states to work out their systems of class actions, even if they are not being successful nowadays, which doesn't make any sense in my humble point of view. Also, if we put it in combination with the future legislation of the third-party funding, my idea of the future in the class action regime in Spain is quite pessimistic, because they are not going to impose or to solve all the problems we are having with the class actions, such as not being able to claim for damages with these sort of associations, which are the only one who are entitled to pursue these class actions. And also, if you put it together with the limits for the third-party funding, the result is that we will still go into the Netherlands and to the UK. Well, to the UK not anymore because of the Brexit. So you're really lucky, Mark. But generally speaking, I am quite pessimistic, and I don't think that the future is bright unless we understand that we have to regulate, yes, but also to protect the third-party funding and to let consumers and also associations to use this tool. And I'm going to finish because I want the audience to make your statements, opinions, or questions. Thank you very much.
Thank you all. Maybe to conclude, just to with the last questions of the poll, and let's see if this time it works. Yes. So please answer, if you're still logged in, please answer questions 3 and 4 now. 3 is, will the EU directive on representative actions change the class action landscape? There are only 17 votes so far, so if some of you could still put in your votes, it's pretty even right now? So the first answer is not really. The current popular class action regimes will continue to be the most popular. 35% of you know many countries will fail to implement the directive in time. Well, that's very even. And then yes, I expect to see a big shift, still 26%. So that's interesting. And then the last question, which is, what do you think is the EU directive's main disadvantage? Allow member states to apply an opt-in regime only, its limited scope, or the limitation to qualified entities that may file a collective action. Apparently, a big majority of you think that this last point is the crucial disadvantage of the directive. So thanks very much for participating so actively, and like Ignacio said, if we have a couple of minutes for questions, then this is the time. Thank you very much.
Sure. Do we have a mic or just speak loud? There is one. Okay.
Thank you very much for the very interesting presentations. Yeah, I have a few questions, if I may. I will start with the Netherlands. So if I understand correctly, the directive is giving the option between opt-in and opt-out, so the Netherlands will maintain its opt-out regime. The question is ONCA going to be amended in order to, let's say, reduce the impact of a scope rule? And to what extent you are going to see the possibility to do it cross-border, in the sense that today, if I understand correctly, courts might extend the opt-out regime to people residing outside the Netherlands. Are you going to, are they going to make a change also in that direction, in the sense that it will be possible to extend the opt-out regime also outside the Netherlands or not?
So, to answer your first question, the scope rule will not be amended as far as I'm aware. It will still apply. At least in terms of the Dutch regime, the scope rule still applies. It's obviously questionable whether and to what extent it's actually compatible with the Brussels I recast regulation, because it is, in a sense, quite restrictive, and we still have to see exactly how the courts will apply that rule, but it will still continue to apply. Your second question on the opt-out regime, yes, the opt-out will be maintained for Dutch residents and nationals, obviously, and there will still be the possibility for courts to declare the opt-out regime applicable to cross-border or to international claimants as well. That is up to the court's discretion, depending on the case and depending on the class. So the court can make that determination in a case-by-case basis. So as far as I know, there are no amendments to the current law planned or in place that will change this. The only real change, as I said, will be for dual representation and for cross-border qualified entities bringing claims. So qualified entities established in another member state bringing claims in the Dutch courts. There, the EU directives requirements will apply rather than the Dutch requirements for those qualified entities, which in a sense are less far-reaching or less stringent. So if you're talking about cross-border qualified entities, then you will have different requirements than for domestic qualified entities.
And if I may follow on this, how difficult it is to convince the court to extend the opt-out regime outside the Netherlands?
It's a good question. I'm currently, if we go by the class settlement mechanism, the WCAM, then you can see that courts are quite willing to. That is an opt-out mechanism in itself, but you can see that courts go quite far in admitting cross-border actions and even letting claimants, where the majority of the claimants are non-Dutch, to include them in a class settlement. So if that history is anything to go by, then you could imagine that for certain types of cases, the courts would be quite willing to extend the opt-out. I mean, you know, as a claimant, you can put in a request. I'm not aware of any cases in practice yet where the court has decided that. Again, it's such a young law so far, but I could well see that happen, yes.
Hi. I think I can just speak loudly. Where do I take this? Thank you. Hello. Thank you for the, oh my gosh, this microphone. Thank you for the great presentation, and this is extremely interesting to me. I'm a plaintiff's class action lawyer from the US, and so I'm interested in what Europe is doing with class actions, and I wrote down about 20 questions to ask you. So I will condense it into maybe 1 or 2 questions, and then I will find you and ask you the rest of the questions. But my first question is, it sounds like what I do is probably not really translatable to this new regime or the prior regimes. But if and when you are able to resolve a class action case, how rigid are the courts in then approving the class action? I assume it goes through preliminary approval and then a notice process of some type and then final approval. Is that if parties are able to come to an agreement, are the courts usually going to adopt that recommendation, or do they have a more rigid standard of how to approve the cases once you've come to an agreement?
First of all, in the Spanish case, they are quite rigid. The class action does not change a lot from an ordinary proceeding. So you have to prove that, of course, there is a cause that affect to all the members of the class action. And of course, the party will argue for sure that there is no such cause for the class action, but there are no there are no mechanisms so sophisticated as there are in the USA, and as you have mentioned, and also some others that I know from my experience, not at all.
It's, as far as France is concerned, I usually sit adverse to you because I would tend to represent defendants, so the bad guys. But I would say that this is the first argument that we would, of course, raise, that, you know, i.e. the requirements are, you know, of having a class are not met. But it's difficult to answer your question because we don't have that many class actions in France. As I said, over the last 8 years, we've only had less than 30. I've seen few cases where this was a serious hurdle for the class, where the court said, well, the requirements are not met, but it's difficult to tell that there is a trend or the court is acting that way or the court is very rigid. I think we don't have too many examples to be able to answer clearly your question on that.
I mean, from the Dutch perspective, I guess maybe one thing to distinguish with the US system is that we don't have a certification process. So there is no class certification as such, but there is a commonality requirement or principle. So the courts will assess whether there is indeed a common interest and a common harm that is being alleged and a common interest that's being represented when putting together a class. So that's one of the requirements, obviously. And another one is the representativeness of the claim vehicle, of the claim organization. So that can be a major hurdle which courts have scrutinized if the claim organization is not representative enough of the class that it purports to represent. But if those tests are met, then usually the court will not go into that much of an in-depth analysis at the outset and usually admit the class as such. And then obviously there are other issues, around standing and those kind of things.
Thank you. And then just just one more, and then I will find you. Once you do settle a class and you get final approval, and basically the judges said, yes, you can move forward, all of that, and send the notices to people to figure out what their share is, etc. Is that the same in your context? Do you hire a third party, and then do you use part of the funding from the settlement, or I guess the award in the case of a fully litigated case, then to pay that settlement administrator?
From the Spanish perspective, we have sophisticated ourselves in these terms with the rise of the third-party funding who has been able to bear with such costs. So my short answer is yes, but with the time and just in the last few years.
Mm.
So we're a plaintiff firm, so I can I can relate to that. But we do some of that in-house, again, depending on the case. But yes, settlement administrators in bigger cases are very much used and needed, obviously. There is no clear rule yet under the new Dutch regime as to how, at least if the class action is litigated all the way to the end and damages are awarded, how those damages are to be divided up among the class and pay out, and especially what to do with a potential surplus. So usually there is at least a 1-year period during which claimants need to come forward to collect their share. But then beyond that, it's still a little bit unclear whether the surplus will, and that's up to the court's discretion, whether it will go back to the defendant, whether it will go to charity, whether the surplus will be divided amongst the claimants that have come forward. But to answer your question, yes, there is usually such a mechanism in place in order to make sure that everyone gets his or her share.
Yeah, no, we don't have that mechanism as far as France is concerned.
And just a follow-up question then to Mark. In the Dutch system, so once you've hired that settlement administrator, actually going back to the kind of the logistics of actually disseminating the funds, so under an opt-out regime, you can have claims made or you can have the checks cashed, ways of getting people their money. Do you use claims made and checks cashed, meaning a system in which it's opt-out, so you're part of the class unless you opt out, but to get your money, you actually have to submit a claim form. So even if you don't submit the claim form, you're still bound by the judgment. Your money will go somewhere else depending on the settlement agreement, or the checks cash system where regardless of, whether or not you've made a claim, if you have not opted out, you automatically get your funds. Is that the same way in how the settlement administrators do it?
Not sure if we exactly have that distinction. Again, the system is not as well advanced and as sophisticated in the US. I mean, what you said before, yes, it's an opt-out in the sense that all class members that fall under the definition of the class will be bound by the judgment or the settlement in question. So they are entitled, I mean, they will have the rights under the respective judgment or settlement. They're entitled to the compensation that has been awarded or their respective share of the compensation. Now, they have to come forward to collect it. If they don't, again, then it's still a little bit up in the air what happens with that money, but there still needs to be an active act from the claimants to actually come forward and collect their checks, if you will.
Thank you.
Thank you so much for this awesome presentation. Actually, class action was also one of my top favorite topics during my studies, but back then in Europe it was almost non-existent, and in Switzerland, still has not been really improving, but awesome, and I could really personally listen to you for another 2 days, but let's go also to the other topics. Thank you so much. Maybe a round of applause before we go for the break.